under 226. There are, I have brought to the number of
Application was
judgment.
filed under Order 47 Rule 1.
No, it would not lie. Because that is
Application was
a
filed
red
under
court.
Order 47 Rule 1.
No, my lord, that
And that was arising out of a civil dispute.
maybe. But
What
I
is
was before the
respect of
Constitutional
226?
Court. Revision is barred. Revision is barred under CPC. I didn't come here in CPC. I came under 227. My lord, please, my lords. My lord, my application under Order 11 Rule 12 was just by trial court.
So how will a intra-court appeal lie?
Yes, my lord, it would lie.
How?
It would lie because the power exercised while deciding the review petition is under Article 226, 1963 Supreme Court. Would say that.
Is akin to 227 powers?
227 was exercised in the writ MP. Thereafter, I preferred a review petition. I am here before my lords to challenge the order passed.
The
on
review arises out of the NP.
It may arise, but
Then, Mr. Lalwani, we will not permit you to challenge the original order. You can only challenge the review order, not the original order.
yes, I'll just say that it is error apparent of the record. Whether the order, the original order has been passed rightly or wrongly.
So that you can't assail before us in intra-court appeal, because that is an exercise of 227 powers.
I do. I am not saying to my lords to reconsider it. It can be remanded back even. It can be even remanded back because if I am able to tell my lords, show to my lords that the order has been originally passed. It has been passed without appreciating the law.
Maybe, but not in an intra-court appeal, Mr. Lalwani.
My lord, it can be, my lord.
You say you are coming against the review order.
But there are two judges.
If review had modified the earlier order, then of course you could have had that plea that it is akin to 226 power. Though it is not 226, it is still a power under CPC.
Any review, because 227 was also decided by a writ court, and any order of review passed by a writ court is always under 226. There are, I have brought to the number of
Application was
judgment.
filed under Order 47 Rule 1.
No, it would not lie. Because that
Application
is
was
a
filed
red
under
court.
Order 47 Rule 1.
No, my lord,
And that was arising out of a civil dispute.
maybe. But
What
I
is
was before the
respect of
Constitutional
226?
Court. Revision is barred. Revision is barred under CPC. I didn't come here in CPC. I came under 227. Therefore, the power.
227 will not permit you to file an intra-court appeal.
My lord may not permit us, my lord, but law is there. Law permits me. But law permits me.
Mr. Lalwani,
Our exercise,
Mr. Lalwani,
review petition.
there are two things. One is when review is declined,
My lord.
then you have to challenge not only the order in review but also the original order.
Maybe, my lord.
Another is a review is allowed and the original order is reversed.
My lord.
That is not your case.
My lord. No.
So the 29th May 2024 original order,
Yes, my lord.
are you assailing that?
I am not assailing that indirectly. I am assailing.
No, direct. The question is not directly, indirectly.
Yes,
Are you
ma'am.
assailing that?
I have followed my lord's query. I know my lord's putting me in a trap. I don't understand that, but let me clarify.
Yes.
What I say is, my lords will have to peruse the original order, saying whether that order has there's an error apparent on the face of the record, whether it
That
whether
we can't look at.
could be reviewed, whether it could be
No
reviewed.
review was registered.
My lord,
No review was registered.
it was
No
listed
review
under
it was
the
registered as MP.
my lord.
See the order impugned, 5525.
I'll answer that query. I am answering that query. Original petition was filed under Article 227.
Yes.
As per the amended High Court rules, either a separate review petition could be filed or by an IA, the review could be sought in the same petition.
Yes.
So I filed an
You
IA
filed an IA for recalling the order, modification of the order in the same miscellaneous petition.
petition.
And
That is
miscellaneous petition, the powers exercised under
My lord,
Article
my lord,
226.
that two-way provision is made in the rules. So I filed the IA for recall of the that is in the review. And review powers are exercised by writ court only under Article 226. It is not CPC which this power is exercised.
Please look at your application, annexure A7.
My lord, my lord.
Shows that it is a 226 petition.
My lord.
Page 38.
My lord. 38.
P7,
What?
A7.
I have just said that It is the application, because we were in those days.
No, please read under which provision have you filed this application?
I am reading the head note. It was mandatory for the office to mention the provision of CPC and
Have you
mention.
said read with 2 to 6 or 2 to petition under 2 to 6, read with so and so?
My lords have rightly caught me, my lord, I do agree. But even I say, assuming, mentioning a wrong provision does not.
Not wrong provision, Mr. Lalwani, correct provision.
No, my lord, it is not CPC. I would with due respect submit.
Is it
that
not arising out of a civil suit?
It is out of civil suit.
After out of civil suit, you prefer a 2 to 7 petition?
I came under constitution, not under.
Then you continue to apply CPC and on 47, you approach the court rejects your review application.
The court wanted me to mention this, so I mentioned it. Mentioning a wrong provision would
That is not, Mr. Lalwani, what the report says.
It is the contents of the placenta has to be seen of the application and the prayer. The prayer is also be culled out from the placenta of the application. That would be the correct position, my lord. Mentioning a provision or not mentioning a provision, mentioning a wrong provision or correct provision is not the, it is whether this court, the writ court has exercised power of review under Article 226, that is only to be seen.
How
Whether
is the court exercise powers under 2 to 6? When you file an application, is an application under 47 not maintainable?
My lord, kindly appreciate. I would again repeat the cause of repetition, my lord, that I was in writ jurisdiction. I was under Article 227.
You did not, Mr. Lalwani, you did not file a 2 to 6 petition.
My lord, it was actually under 227 was filed. That became a
Yes.
writ court. I never came in 115 CPC. I came in 227. The moment I exercised jurisdiction at 227, this court also exercised jurisdiction at 227. Then any review,
No,
even
any order under 2 to 7 will not be assailable in an intra-court appeal.
No, man, let me clarify further, my lord. In a petition under Article 227, no rules, no procedures prescribed, principles are adopted from CPC, even for CHASPA, for surveys, for amendment, every order would be under Article 226, every order.
Mr. Lalwani, that is settled by a full bench of this court.
Yes.
Intra-court appeal not maintainable.
That every order would be, the Supreme Court says that the power exercised for review is always under 226, and my High Court Division Bench also says that.
What is the citation, please tell us?
AIR 1963, 1909. I have uploaded it for my lord's
The
convenience.
original case was not under Article 227.
I
In
do
that
agree,
case-
but I was in
In
this.
that case, the original petition was under 226.
My lord,
And 226 review power was exercised.
my lords are very rightly pointing out to
Yes,
me,
that case
but
was
the
not in
fact
this
remains, I did
227.
not come here under 115. I came here under the constitution.
Because no,
Therefore,
115 was
it-
barred.
it
Therefore,
became-
you
there-
find the petition under
that
227
court,
and thereafter filed an application for recalling the
my-
matter in the petition filed under
my lord,
227. Then how
proceedings would be under the provisions of constitution.
issue is that this was the MP and the review were not the original jurisdiction.
My lord, I am not on the original side. I am on the side the provision under which the writ court has exercised.
Show any
its
judgment
jurisdiction.
show any judgment wherein the 227 petition was filed, thereafter the recalling application was, our review application was filed, and that order was, the intra-court
I
appeal.
can give an example where the.
Not example, any judgment?
I can give a case of this court where my similar petition was admitted and stay was even granted. That is pending.
Any final
My
order?
earlier bench
Any
of
final order passed? Any final order passed?
still pending, my lord.
Pending, so that is not binding.
Still, no, that was also after 227 in the DV 1. Headed by Justice Patnaik ji and Ajit Singh, they stayed
has been
it.
entered.
And this issue arose up.
Thereafter,
And I answered this
judgment
1963 judgment.
judgment in the matter of Shailen.
My lord, may kindly just
Full bench
appreciate.
judgment in the matter of Shailen. Shailen Singh's case, full bench judgment is there.
That says, my lord,
Upload that full bench judgment of Shailen Singh.
well, kindly just appreciate this, my lord.
Upload that judgment.
Let me just apprise, my lords.
There is not a single judgment which says that the review, any order passed in the review of 227, intra-court appeal will be made.
My lord, why I am trying to explain is, and how I am trying to explain is that under 227, even application for amendment would be under 226. Even an application for CHASPA or publication would be under 226.
Mr. Lalwani, that is an incorrect statement because Supreme Court has clarified powers exercised under 2 to 6 and powers exercised under 2 to 7 are completely different. Court may have powers of 2 to 6, For example, in Armed Forces Tribunal, recently Supreme Court in Purushottam Das has held powers under 2 to 6 will be available, not powers under 2 to 7, because that is not a tribunal under your jurisdiction. So you can't say that it is akin to 2 to 6, it is not.
Let me again repeat my submission. What I said is, while deciding powers under 227, every proceeding would draw principles from CPC, but would be under 226. Powers would they?
That is not the correct position in law, Mr. Lalwani.
It does not have any procedural powers. They are all under 226.
Judgment
No.
of full bench judgment is uploaded in ERP at serial number 3. Shailendra Kumar, वो आप देख लीजिए.
Shailendra Kumar category and discusses the distinction between powers under 2 to 6 and 2 to 7.
I am not disputing that. I am not disputing
You
that.
are actually arguing that powers under 2 to 7 is actually powers exercised under 2 to 6.
No, I am
And
not.
the full bench has drawn a distinction.
I don't say that. I have not read this in just now, but I can very well say that 227 has a different scope, 226 has a different scope, but while acting in 227, all the jurisdiction which the court has for the procedural part, it is under 226. Procedural part is not
It is a
provided
correct
by
argument.
any high court
See the
rules.
judgment of full bench first and then argue it.
Then
It
let
is
it
not
be
correct.
after-
Para 10 says
Let
that
it be
all the powers are supervisory power.
Maybe after tomorrow, I'll go through it.
Not 2 to 6.
Let it be tomorrow, I'll go through the judgment also. Before going through it, I should not make a
Judgment is also not arising
But
out of-
as far as I understand, my lord, it is procedural will be always under 226. Even I said ki Chashma will be under 226.
Mr. Lalwani, please look at Shailendra's judgment in paragraph 10, relying on Radhesham judgment of the Supreme Court, has noticed the difference between 2 to 6 and 2 to 7 power. This was referred by the Supreme Court to a larger bench, and larger bench in Radhesham has clarified
I
that
just,
2 to 7 is supervisory and judicial.
I do. I said about the procedural part, there are no rules for that. Even
May not be, but there is no intra-court appeal permissible.
My lord, intra-court appeal that issue will arise later. First question is whether reviews is while deciding review
And
application.
you should have got that court has rejected your review petition.
No, those powers exercised under which code? Under which law? That would be
CPC.
first. It can't be in a CPC, my lord. It would be all in 226.
Sorry, that Mr. Lalwani is incorrect proposition.
My lord, I'll
2
go
to 7 petition, anyways,
let me just go through it. I'll argue it up tomorrow.
a request for adjournment is made on behalf of the appellant at request list next week.
My lord.
Serial number 3, Sachendra Kumar Raghuvanshi.
Okay.
Annual increment,